Thank you all for coming. My name is Adam Lipsius. I am a 2L at the law school, treasurer of Silicon Flatiron's student group, and for 30 years a filmmaker. So copyright hits very close to home for me. And I came to CU Law in hopes of being on the cutting edge of this very personal issue, and you don't get more cutting edge than this. The panel we've assembled is phenomenal. It is led by Reid, who is my copyright professor. He scintillates us normally with charts and graphs and overviews, but occasionally with an electric guitar, and has brought copyright to life. Sarah Jeong, Deputy Features Editor at The Verge, is also on the cutting edge of this issue, and I'm sure we have all read many of her opinions and articles about what's happening in copyright. Anne-Marie Bridey, Senior Copyright Counsel at Google. If you haven't had a chance to speak with her about this, you will not find anyone better informed on the topic. Ben Sheffner, SVP and Associate General Counsel, Law and Policy, Motion Picture Association Incorporated. He is a leader in the field and has opinions very close to my own. And for those of us who were able to attend Professor Pam Samuelson's presentation already, she needs no further introduction, though I will point out that her husband let me know that she is a certified MacArthur genius, and no one in here disputes that. So without further ado, let me present the panel.
Thanks, Adam. Okay, so the panel was to continue along with Pam's excellent keynote and interrogate from the point of view of, let's say, I don't want to say grizzled, but veterans of copy fights over the last quarter century. To keep this conversation going about where AI stands relative to the past. So in lieu of lengthy biographies, I am going to turn to each of our speakers to react to Pam's keynote. And I think Pam's keynote suggested that our politics are perhaps not all that different, that perhaps maybe seen these things. And so I thought I would start with Sarah Jeong, who has perhaps a provocative set of views on this topic. Sarah, I'll turn it over to you to
So I'm Sarah Jeong. I am a lawyer, but I practice as a journalist. I do not litigate. I do not practice at the moment. I've been interested in copyright law for a really long time. My views on this matter, I think, are maybe a little bit divergent because they connect back to copyright in the sense that the Constitution, the 76 Act, is based on this one line in there about for the progress of the arts and sciences, right? And what we have right now is with generative AI, we have an industry that I think that it would be foolish not to ignore the fact that this entire industry is reliant. They came in believing that the Google Books cases would protect them. They came in believing that Perfect 10 would protect them. I do in fact think that that situation set up where we are at the present day. And these industries, the series of upstarts, the many firms involved, they have ushered in a wholesale destruction of human knowledge and culture that is as significant as the burning of the Library of Alexandria. And the paradigm in which this is happening is also completely new. We've never seen things make less sense because there are more things out there. And it is easier and easier to make content that no one really wants, no one really wants to look at, that is deceptive, but more it's just sort of there to fill space, right? And because it's there to fill space, we're just getting less and less intelligent. We read less, we know less. It's hard to find things less. And you can see this, people in academia will know that this is looming over them like one thing, AI is getting sort of crammed into every part of our academic institutions. But I think it's most evident in this horrible feedback loop where first you have, because of the situation that's set up where education is considered a commodity and not, what it should be, you have students who are using ChatGPT to fulfill assignments. So they're using the busy work robot to do the busy work because education has been set up into this busy work mine. You have professors who are using ChatGPT to generate exam questions because, again, they're answering the call for busy work using the busy work robot. And then you have them generating academic papers that they send to journals, and the journals are sending them to peer reviewers who are using AI to do the peer reviews because they're sick of doing peer reviews because, again, busy work goes to the busy work robot. But some outcome of this is that it's getting harder and harder for us to figure out what's real. It's getting harder and harder for us to figure out what the world is like. And things are becoming more and more obfuscated. And I think that we are seeing some really early evidence that shows that, we read less, we know less, and we're just shifting away from a culture of literacy into a culture of orality and into oral folk traditions, essentially, because we don't really want to engage with facts, with logic, with the world as it is. And I think we see that directly reflected in our politics as well, and that's also inflected the internal politics around copyright and AI, frankly. Not because of the lawyers who are engaging in Calvinball, but because fair use itself is a heavily fact-based doctrine when you apply it. But the facts that we're working on come from the industry, and the industry is out there claiming that we've reached AGI, which is a fake thing. That is it's a series of benchmarks that have a very, very specific financial incentive behind them. It will realign the entire industry because of this deal between OpenAI and Microsoft, right? AGI is fake, and it also is ridiculous to say that we've reached that point. How are you supposed to trust those people to give you facts that make any sense or pertain to reality while you're attempting to do a fact-based analysis? This is what I mean. We are verging off of this cliff, and when I see this happening and I zoom out, I go, well, what was the point? If we are supposed to have the Copyright Act to progress arts and sciences, but we are looking at culture falling off a cliff, and I only talked about being able to know things because that's what I find interesting. But it's you are seeing this, I don't want to say dilution because of the highly specific use in cadre, and also because I feel like it mixes up trademark law in a way that I don't like. But you are seeing a watering down of culture, or maybe a consolidation of culture in a really horrible way, from a purely aesthetic sense that I just don't really want to get into. But everything is verging into the same thing that is going to now feed the models and is cement culture in the sameness that does not progress the arts and sciences. And so that itself, I think, is really hard to measure. So maybe I don't even really want to bring that up. But yeah, I think that we're looking at an apocalyptic event here. And it is one that people went into because they looked at these early fair use cases and went, yes, this is exactly the same thing as what we're doing, without looking at the fact that these fair use cases were about providing value to human beings. I look at the secondary liability cases, and they're all proxies for harms to the consumer versus use to the consumer, right? We talk about interoperability. Interoperability is good because of what happens to the consumer at the end. But what you're looking at with these cases is companies versus companies. And when I see what generative AI is doing, the greatest harm is happening to people who don't have standing to sue. In which case, again, I go, what are we doing here? What is copyright for? What was fair use for? And so that is sort of my position on copyright and politics.
All right, so we have been here before, nothing to see here, too, and I wrote it down. Widespread destruction of human culture, destruction of the Library of Alexandria, AGI is fake, complete breakdown in trust, verging off a cliff, fair use is destroying progress and watering the culture down with sameness, apocalypse. Okay, within that milieu, I'm going to turn to Anne Marie and then to Ben. Where do you find yourselves on the continuum that we have?
Yeah, so that's a pretty provocative act to follow. I think that, you know, there are some polls in the debates on generative AI and how it will impact ultimately, you know, the future of human culture. I mean, Sarah is, I think, you know, fair to say on the doomer side of this, kind of the boosters and the doomers. I am more optimistic than Sarah is, I think, about the potential for this technology to improve our lives. And I don't think that this technology fundamentally undermines in any way the promotion of progress in the knowledge and human sciences. I just think that we are in the throes of an extremely disruptive moment right now where, you know, I think a lot of the sort of threatening aspects of the technology are in the foreground, and yet people are not yet fully aware of because it hasn't sort of filtered out into the broader culture of the more beneficial uses that we will see for this. So I think, you know, ultimately I'm more optimistic than Sarah about the potential for this technology to improve our lives. I am more optimistic about human resilience in the face of new technological developments that are disorienting, you know, at first. And also about the enduring value of human creativity. I mean, I think that there's a huge assumption that somehow there's going to be a race to the bottom and that nobody will value human creativity anymore and that nobody will any longer have judgment about what is quality and what is worthwhile. And I just think I just have greater faith in people, I think, to believe that they are not going to be somehow fundamentally destroyed, you know, by what is an evolution in existing technology. And I guess I'll just say too, I don't think any of the developers went into this thinking this is like slam dunk fair use, there's no question about it, right? Anybody who understands fair use understands that you never really know when you've got a totally new thing, a new use that hasn't been adjudicated before, right? What you do is you look at the past cases, you look at what you're doing now, and you say, you know what, I think this is like, we're talking about kind of expanding the horizon, we're asking a new question. You know, so I don't think it's accurate to think that anybody sort of went to the bank on AG v. Google or on, you know, on Perfect 10 v. Google. But, you know, I do think those cases are supportive, you know, of this being a fair use. And so I guess, and I didn't introduce myself. I'm sorry. It was just.
I think we we have got to get one more on the table. So Ben, Pam, I think mined most of the good quotes from the earlier battles, but there was one that didn't make it on the table. So one of your predecessors, Jack Valenti, once testified to Congress that the VCR was to the American film producer and the American public as the Boston Strangler is to the woman home alone. How have things progressed in your part of the world?
Reid for inviting me and Silicon Flatirons as well. It's an honor to be here. Luckily, I have a lot of experience responding to that. So I'm going to get to that.
It's obligatory, I know, but please.
Is it? No problem. I will get to that in a minute. So I'm an attorney at the Motion Picture Association. As you probably know, we represent the 7 major producers and distributors of motion pictures and television shows here in the U.S. I've now been at MPA 15 years. For the 10 years before that, actually one of the very first cases I worked on as a young associate at a law firm in Los Angeles was the Grokster litigation on behalf of what were then the AOL Time Warner plaintiffs. So I've been through some of these battles, and I think that I agree largely with the description that Professor Samuelson helpfully provided us a few minutes ago. And there are parallels between what we're seeing now, but I also think that there are significant differences. As Professor Samuelson mentioned, a lot of those older battles were very industry specific, whether it was the publishers of articles or the motion picture industry, music, etc. AI affects all of them and many more, which is true at a high level. But I think there's a lot of differences once you scratch below the surface a little bit. And let me explain a little bit about what I mean. All these industries are different. And I spent a lot of time in groups of representatives of other creative industries, whether it's music, photographers, graphic artists, authors, et cetera, news organizations, et cetera. And all of them have sort of different creative processes. All of them have very different economics. And all of them either want to use AI in different ways or will be affected, or already are, or will be affected by AI in different ways. And frankly, AI has scrambled a lot of the traditional alliances that we've seen in many of these battles over the past 30 years or so. What do I mean? Let me give a really specific example, and that has to do with news organizations. And I would often I do a lot of IP work, but I also do a lot of First Amendment work, and attend conferences of media defense lawyers, First Amendment lawyers. And sometimes I'm kind of the odd man out. I'm the big pro copyright guy, where the news organization lawyers, the defense lawyers are, oh, it's all fair use. What we've seen over the last couple of years, that's been totally scrambled. Who was first out of the gate with a very aggressive lawsuit against OpenAI and Microsoft? The New York Times. I believe that was in December of 2022. And a number of other news organizations have filed lawsuits, at least half a dozen lawsuits against the AI companies. They see it as a very direct threat to their business model. Some of these are producing either sort of verbatim or near verbatim copies of news organizations, taking away traffic to the news organization's websites itself. They have been extremely aggressive in enforcing their rights and in some cases seeking legislation to protect their copyrights. We at the Motion Picture Association, I think, have taken a very judicious view of AI. We were certainly not first out of the gate filing lawsuits against these companies. More recently, 3 of our members have filed lawsuits against 2 companies, Midjourney and Minimax. Not only on training, but importantly, they had excellent, very strong examples of infringing outputs. And I think in the 59 cases that we have now, I think the strongest cases, the ones that the plaintiffs are most likely to prevail at the end of the day, is ones that are based not just on training, but also on showing infringing outputs. But we've also acknowledged that, our members have been using AI for decades. It's not a new thing, especially in the post-production process. All sorts of AI kind of embedded in the software that does, all sorts of visual effects, technical processes like rotoscoping, de-blurring, de-aging, color correction, all that kind of stuff. And I'm sure that AI will be incorporated more and more into those processes in a responsible way that respects copyright. So we can get more into the details, but yes, there are similarities to some of the debates we've seen, and I think a lot of the debate is becoming very polarized. I mean, if you read those 10,000 comments or so filed with the Copyright Office back in 2023, there's a lot of them that say training is categorically fair use or training is categorically infringing. We at the Motion Picture Association were very careful not to say that, to emphasize that fair use is a fact-by-fact analysis. The Supreme Court has told us multiple times there are no bright lines in fair use. And, we have these 59 cases, and we're not going to get the same results in all of them based on the particular facts of the case. And, we're at a technology center. I would say, that is a feature, not a bug of fair use.
All right, I think we have teed up 3 excellent veins, and I'm going to hit them in turn in a slightly different order. We'll talk about tech companies. I think we'll talk about creative industries, and then we'll talk about culture. But before we go to that, Pam, I think we have stretched out the window of possibilities here. I want to come over to you for any responses or rejoinders before we move on.
So I want to just make a couple of remarks about anxiety and about how anxious people are about AI generally, but also about generative AI. So there's both excitement and a great deal of hand-wringing. The future of jobs is something that many people, including law students, are thinking about. And so when I think about sort of the political climate about AI and generative AI, I think about sort of that anxiety is like out there, and this kind of jobs displacement problem is not a problem that copyright can solve. So I sometimes say myself, copyright is not a jobs program, okay? So I love many artists and authors, and I'm a big consumer of copyrighted stuff. And I, like Anne-Marie, think that if you really think that the generative AI is gonna turn out slop, then I think human authors stuff is still going to do pretty good. I certainly will be. So I think we have some regulations to do about maybe about disclosures of the use of AI and generative AI in particular, but also the people who are at the most risk of losing jobs aren't the authors and the artists. They're basically lots of white collar people. I think I saw on Twitter recently, here's the 50 jobs that are most at risk with AI systems, and here's the ones that are basically going to be just fine. And artists and authors weren't in the top 50. And so if we have a general problem about what is artificial intelligence going to do to employment in the US and more broadly, that's a larger problem than copyright can solve. But the anxiety about jobs loss and displacement has been part of what's fueling the kind of the upsettedness of a lot of the entities and people who are concerned about this. In terms of culture, yeah, some of the stuff that's been generated is just junk, but some of the stuff people really value, and people of all different types, I mean, are using it for everything from planning a garden to planning a garden party, so I think that we just have to develop some cultural norms about uses that are important. And in terms of sort of the outputs issue, with the first of the cases to kind of think about what can be called adversarial prompting, which is when I haven't been able to get the damn generative AI to cough up something that's really like my thing, but I want to say it's an infringer. So I'm going to adversarially prompt it by feeding some of my work in it and then asking for it to generate something like it. And that's not the ordinary use of the thing. And one of the sort of issues that will be, I think, interesting in the New York Times versus OpenAI case is whether adversarial prompting is basically a kind of thing that discounts that you were able to get some outputs. Now, I think I agree with Ben. The question about whether if you're coughing up and your Midjourney and some of the others are allowing cartoon characters and other visual images to be generated, that looks a lot more like infringement to me than other things. But again, if some ordinary person used Midjourney to generate a picture of Superman at the supermarket, I don't know that I think that that's the kind of commercial output that would be the basis to shut that thing down. But I do know that, as Blake mentioned at the beginning, um, uh, quite a few of the complaints ask for destruction of models as a remedy. And now that's a remedy that even if infringement is found, courts have discretion not to do it. But I sometimes say that copyright is the only law already on the books that could bring the generative AI industry to its knees just like that. Now the bubble may burst anyway, right? Because you see discussion about the bubble, the AI bubble maybe bursting. So it could get destroyed in more than one way. But I think we're all hoping that maybe that doesn't happen.
All right, we have a terrific slate of topics to march through here. Anne-Marie, I want to turn to you. And I often teach about your company, but it's a very different version of your company that is from 20 years ago. And we often talk about factor 5 of the fair use analysis as the sort of vibes of a fair use case. And when we talk about the early cases, we can't think of better vibes than Google image search when it first comes out, of Google Books when it first comes out. These are magic technologies. We're now in an area of the techlash, which Pam mentioned this morning. Pam is talking about anxiety, about jobs, about adversarial prompting. We're in a more complicated time. I'm going to turn it to you. Try and contextualize what the arc of tech companies looks like in these fights.
So, I mean, I still think these tools are magical tools, and I still think that they have a tremendous, ability to serve the public's interest. I mean, it's not for nothing that OpenAI has like 190 million. I don't even know what their monthly active users are, but there are people who are using this technology, who are finding it beneficial in their lives, who are making new creative things with it, who are using it to help them do their jobs, and so I think that all of these big cases, these are, at the time that these cases sort of hit the docket of a federal district court, it is a totally new thing, that is out there. And there's a tremendous amount of anxiety around it and opposition. And that's how you end up in court fighting over whether something is a fair use, and I think that, over time, even as these cases make their way through the courts, because it takes years for these cases, to get from a federal district court up to the Supreme Court. During that period of time, often what happens is the technologies that seem so terrifying, at the moment the case is filed in a federal district court, by the time it makes its way up through the appellate court or we get to the Supreme Court, the technologies have become embraced and adopted and incorporated into the way people live their lives. And they no longer seem like they're some kind of, incredibly disorienting adjunct to something that we all were used to doing, right? We find the ways to make them helpful to us and to kind of domesticate them and to make them seem not strange and to make them seem not threatening. And so I do think, there's a professor at Princeton, Arvind Narayanan, I will say his name incorrectly probably, for which I apologize, but he, his position is, look, these are going to be normal technologies, everybody is thinking that this is going to be incredibly apocalyptic, but what's going to happen is these technologies are going to diffuse their way through culture and society and the economy in the ways that previous technologies have done. And there will be displacements, and there will be new jobs created, even as old jobs, are phased out. And so I do think that that's what's happening. Like, we just seem to be in a moment of extreme kind of intense anxiety about this, but I think that if we look at the arc of the way all these cases have played out, we see that over time, people find ways to kind of domesticate these technologies. And so I think that that's, I will say that in terms of the adversarial, And, that these are general purpose technologies, right, that are capable of substantial non-infringing uses. Like copyright law already has a framework for thinking about this, right? Do we say you shouldn't be able to distribute the thing because some people can make it infringe, right? If they work hard enough and they try hard enough, they can make it infringe. Or do we say, no, we think there are so many potentially beneficial, cool, non-infringing uses of technology that it would be a net detriment, right? And would sort of harm human flourishing if the technology is not allowed to continue, as people figure out how to, how to make it work for them.
Can I just interject here? To tie it back to the Cox case, just for a minute, that's before the Supreme Court. The Solicitor General's endorsement of broadband services as having substantial non-infringing uses draws from the Supreme Court's Sony decision, this particular concept. And if the Supreme Court justices find that meme, right, that metaphor to be powerful and to sway them, that will have ramifications for the generative AI companies, I think.
Well, and, let's pick up this metaphor of domestication or normalization, because I think that's really helpful. From Pam's talk this morning, I think we've seen a range of technology products that have been successfully domesticated and survived the copyright gauntlet in one way or another. And then we also have a graveyard of technologies. I'm thinking about Aereo, I'm thinking about that have had important effects but are not part of our lives today. I want to open up to the rest of the panel. How do you feel about this notion of domestication and normalization of generative AI? Where are we? Sarah, you want to kick us off?
Yeah, so I think that humans will survive in the sense that, I mean, like, not all of us will be dead as as climate change progresses. This is what I mean. Like, there will always be resilience, but that doesn't mean what you have at the end of the day is good. And I actually do agree that copyright is not a jobs program. This is one of the reasons why I talked a lot about the users and what the harm is to society versus creators. Because that's yeah, things are always shifting and changing. The thing that I am really concerned about with AI, copyright, and so on is that if you pull all of the fact pattern out and you look at the trends and you assume that we live under full communism, is this still a problem? And yes, it is. It is actually still a problem. We still have de-skilling. We still have the slop problem. We still have a decline in literacy. And that seems to me to be very, very alarming. Even if we, throw people into full health care, full housing, if we make it so that artists can create their works without, while having all of their needs taken care of, you still have a problem. And that's that I think is really bad. The other thing that I'm going to sort of point out is that although there will always be a demand for human works, I think we can see in other industries what has happened to the slopification of an industry. So fast fashion, for instance, I think is probably the most easy to grasp example. Fast food also. But if you create systems in which the worst alternative is just cheap and easy to get, people will take you up on it. Even if they know that it's not very good for them, or they're oh yeah, I really shouldn't, they'll still do it. And I think right now we have set up a system of consumption that privileges slop. And that's why we're seeing people sell books that tell you that certain poisonous mushrooms are actually good. It is just sort of, I think maybe one of the most ironic sort of setups here is the rise of Spotify Core and weird slop artists on Spotify, where we have set up a privatized compulsory licensing regime with Spotify. It's Spotify's just a weird animal. But it's Spotify was supposed to respond to the disruptive technologies around Napster and so on. Like people want to listen to music on their little devices, right? They want to be able to have access to all of the music, and they're willing to pay a certain price point to get the Napster experience, essentially. That is the solution of Spotify. It now has a big pot of money that it redistributes to the artists. This is how we have domesticated peer-to-peer file sharing. But we have also now created a structure in which people are incentivized to make garbage and put it through Spotify so that they can get the plays, so that they can get the money. I don't really know what to say about that. I think that's kind of a disturbing outcome. So like, I do think that we are looking at the ongoing domestication of technologies. I don't know if the outcome has been all that great. Yeah, that's sort of where I am with that.
So we've got 2 votes for domestication going forward, different valences of what that might mean. Ben, Pam, thoughts on this notion of domestication of AI?
Sure, and I think there are good examples from the last 20 years or so of sort of domestication of what were once kind of these wild animals of services that engage in blatant copyright infringement. Napster and Grokster are great examples. So those are cases where the plaintiffs sued and won. If those cases had gone the other way, what we would have seen, the law would have been, it's perfectly fine to run a peer-to-peer service where millions of people can upload and download songs and other works without permission. And we would have had peer-to-peer. And it would have been beautifully designed, and it would have cut out all the spam, and it would have been really, really easy for anybody to use. And it would have further destroyed the recorded, probably the motion picture industry as well. The courts domesticated the online music distribution. Perfect right now. We still have the Cox case, which is about peer-to-peer. But the fact that courts essentially shut down Napster and Grokster in the form that they were existing at the time enabled the rise of Spotify and the many, many other services. Another great example is YouTube. Remember, YouTube was not originally a Google company. It was a startup that eventually was acquired by Google. Those pre-Google years, it was a free-for-all. Remember, they got famous for hosting clips of Saturday Night Live. That's why people would go to YouTube. Google bought them. They also got sued by Viacom. But an interesting point about the lawsuit that's often forgotten is that the claims were cut off as of the date when Google implemented Content ID, which is a system that basically filters out works that the copyright owner has identified as not wanting to be on the platform. And it works pretty well. And because YouTube was essentially domesticated, YouTube has deals with most of our members of the Motion Picture Association. Piracy, I wouldn't say piracy has been eliminated from it, but Content ID has largely taken care of the problem. So there is a history of this. What exactly will domestication look like in the AI world? Not exactly sure. I think, obviously there's been a lot of discussions about various forms of collective licensing. I think it's really important to distinguish between those various forms that Professor Samuelson mentioned, whether it is compulsory licensing, which at least we at the Motion Picture Association would strongly oppose, but there's various other sort of gradations among that, whether it's completely voluntary, collective licensing. There's something called extended collective licensing, which is kind of a hybrid between compulsory licensing and completely voluntary licensing. And I think the answer will, again, probably be different industry to industry. We've said very clearly in public filings that we do not believe collective licensing is appropriate for our industry, but for others, it may be. So, but, there's still a lot of details to work out. As Professor Samuelson said, it's very complicated and a lot of practical issues to resolve before any of those could really be successful.
So maybe even when copyright intervenes in the long run, Pam, thoughts on domestication before we switch gears and think about the creative industry?
So I think that Ben's mentioning of Content ID is is a good one to recognize that private ordering can actually be part of a solution. So it isn't necessary that courts or the Congress necessarily has to get in, but there are proposals made periodically about ways in which it's possible to do things through private ordering that you might not be able to do any other way. So another example is actually robots TXT. So this is a protocol that exists so that if you put content up on the internet and you don't want your stuff to be cached and indexed, you can basically put the tag there, and the tag basically says, don't do it. And you know, it's a private ordering solution. There's a lot of debate right now about, you know, should we have more regulation of scraping? I think that the calls for scraping, and there have been several different legal theories that have been tried to challenge scraping. Obviously, copyright only one of them, and none of them has really kind of like taken yet. But I think that people who are thoughtful in this space will be trying to think about ways in which private ordering can do some good. Also, a lot of the generative AI companies in particular have installed what they call guardrails, so input filters and output filters and other technologies to try to mitigate the outputting of harmful material. And that's not just copyrighted images. One would want them to do a great deal to try to stop child porn and other hate stuff. And so technology can be not only part of the problem, but part of the solution. And I think that, you know, putting on the table that there's like, it's not just the courts, not just the Congress, not just the Copyright Office that is involved in this, the domestication process. I think there's also some private ordering. And just to respond briefly to Ben, I would say that the reason that we have these digital music services that are basically all you can eat is because of Napster. Napster and Grokster basically said, okay, you can have everything for free, but there are some risks that you do. And so Apple goes to the recording industry and said, wouldn't you like to make at least a little bit of money? And so at the time that Napster was happening, all of the recording industry companies wanted to have their own music service. And they wanted to have like really technically protected and make it sort of difficult to use. And Napster said, hey, lots of people want to use this stuff. Let's make it easy. And so I would say that Spotify is more a child that happened because of Napster than otherwise. So I do think it's a great thing, and it basically not only protects people from bad stuff that sometimes the copyright owners would feed bad stuff to pollute the files and hurt your hard drive, but also, you know, most people just want an easy way of doing stuff. And so if you keep the price low enough and you provide a great deal of variety, then people are willing to do it. So, so that was a kind of domestication, but it wasn't just that the music industry kind of like said, oh, let's just have a real new type of thing. I think that was an evolution also.
Ben, I'll give you a chance to respond when we shift to the creative industry, but before we lose the thread, and I think we need to talk about it in the context of technology companies, I want to give Sarah and Anne-Marie a quick chance to respond on robots.txt, on technological guardrails for outputs, anything on that front. Sarah, you want to go first?
Yeah, I think really robots.txt is an interesting one because up until recently, it was a fantastic example of private ordering. The web sort of organizing itself in terms of like, oh yes, I want scraping, I don't want scraping, and everyone sort of followed it. It was a voluntary norm. And then the AI companies came in, and a bunch of them just decided to ignore robots.txt. And because they decided to ignore robots.txt, this accelerated the decay of the web. A lot of sites that had permissive robots.txt, because they liked being indexed, saw that the scraping was happening and were really alarmed at what that was doing to their own content, their own market. And then they made the robots.txt less permissive, which again, also accelerated the decay of the web because that affects archiving, so on and so forth, and indexing, because then now you're pulling out. So you have like, yeah, I think like the story of robots.txt is like a little bit sad almost. And it is part of like the fact that that is beginning to crumble, I think is really alarming. The other part of it that I find alarming is that we saw Content ID actually really early in the story of YouTube. Like that started getting floated pretty early on. If you think about like the timeline there. And the guardrails that I'm seeing coming out of the AI companies right now are really low, like really strangely low. Like Google has a very impressive protocol for like embedding into AI generated content, like essentially a watermark. But that isn't getting deployed in any of the like technologies that are coming out. OpenAI, oh, is it now?
Yeah, Synth ID is in every image that's generated by a Google generative AI image tool.
Is it on the phones? Is it on the Pixel?
I mean, you need like a reader to read Synth ID to see it. You know what I mean? But yes.
Yeah, when we reviewed the Pixel like last year, you could like take photos and automatically add a layer of Gen AI on top of it, and Synth ID was not implicated in any way.
Yeah, so I mean, I don't know, like, it's probably true that there's gonna be an analog hole here, like, you know, where you can just sort of take a picture of a thing and what's embedded in the digital code for the thing is not gonna show.
I mean,
in
it
the
wasn't
picture.
like, I mean, it was all fully encased in the Pixel environment is the thing. Like it was like fully in the interface. You like take the picture, you dial it in, like you're not leaving the Google environment whatsoever. And like that, I think it's like remarkable because it's like, oh, this is a voluntary ordering that is above the current like watermark, right? Like this is a good actor in comparison to the other actors.
Yeah, I mean, I think it's a slightly different question, right? Because Synth ID isn't a copyright management tool. Like this goes to the sort of, are we marking AI generated content because we believe people need to know what content is AI generated, such that there has to be a kind of embedded mark in it. And I think that there are reasons for doing that, you know, but I think also that there are some strange assumptions that come along with it. You know, but we'll see. But I do think the watermarking is a little different. But I'd like to say something else about guardrails, and I think it's really important where we put guardrails, right? Notice that the guardrails that are at Content ID are at the point of the distribution and publication of content, right? So if UGC content, something that users make using a tool, right? They upload it to the platform, which is the point at which it's distributed and the point at which it's published, which is arguably the point at which there is a copyright harm, right? Because once that sort of hits the distribution point, then you're thinking about something that threatens the market for the existing work, right? I think when you put those guardrails at the distribution point, the advantage that you get is that you're able to protect fair uses because you're able to, in Content ID, if you are the person whose content is affected by a claim, say, hey, no, I think this is a fair use, right? And so there's a kind of right of appeal that is baked into that system. Whereas if we say, as a matter of law or as a matter of private ordering, we think you should never, user, be able to generate an image of a copyrighted character, that means if you're the user and you wanted to do that for a fair use purpose, for a parody or a commentary or some other kind of transformative use, you would be unable to do that. right? So I think we need to be really careful when we think about guardrails for generative AI, where we put them, and we need to think about sort of where the harms come from if we put them in the wrong place. And I do think that we need to make sure that when we're working with sort of guardrails around outputs in the, obviously we don't ever want outputs of sexual abuse material, right? We don't ever want outputs of non-consensual erotic imagery, right? But sometimes we do want outputs of copyrighted content because sometimes that's a fair use. And I think we wouldn't want to see a world in which generative AI tools are not permitted to be used for purposes of making fair uses of copyrighted works.
So I want to harken back to Margot's question just a little bit ago about the user interfaces and how they fit into the fair use analysis, and how we haven't really seen any indication of that, in part because these initial cases that we're getting fair use results out of are focused on the earlier stages of the AI supply chain, as James Grimmelman and his co-authors have written about. And then in Judge Alsop's opinion, we see Judge Alsop really slicing the uses into these segments. Could we see if that approach takes hold, where we say we're going to analyze assembling training data, we're going to analyze that differently from the training of models, we're going to analyze that separately from the outputs of a generative AI model and what happens to them? Does that threaten this notion of what you're talking about, Anne Marie, that we need to put guardrails in the right place to make sure we don't suppress what users are doing?
I'm not sure I completely follow the question. So threaten it in what way?
In other words, are we going to see pressure to stop use earlier in the pipeline, or stop training, or stop downloading? In other words, doesn't Judge Alsop's framework sort of suggest that we need to analyze each little part of it?
I think so, and I think that's what the Supreme Court told us in the Andy Warhol Foundation case, right? That you focus on the use, not on the work, right? Because remember, in the Andy Warhol case, Andy Warhol made like, I don't know, 17 or something huge scale silk screens of the image that was ultimately at issue in the case, right? And the court says, we're not saying anything about those and those uses and whether they were transformative or not. We're going to look at the downscaled sample image that was used as a book cover, and we're going to assess whether that was transformative when it was competing against another downscaled image that was produced by a photographer for the purpose of putting on not a book, a magazine cover, right? And so I do think Andy Warhol Foundation tells us that for purposes of thinking about transformativeness and fair use, we need to look at what the use is. So you look, and I think that's the point that I'm making about guardrails, right? Is that I use a tool to make a picture of something, right? Like we wouldn't say you can't use a pen to draw an image of a copyrighted character, right? But we would care a lot about when you use a pen to make an image of a copyrighted character, what you then do with that image, right? And I don't think that there's a copyright harm that occurs at the moment that somebody is making a picture on their own computer at home, and maybe they don't even do anything with it, right? Or maybe they're trying to think through how they would use it.
Really quick response. And
So
then let's move
I
on.
actually think this is a really interesting, a divergence point in this is one of the places realignment is happening, and it's very, very fact bound. People are using these technologies, and their own behavior suggests that they don't think that what they themselves are producing is user-generated content. They think that what they're doing is they're in a closed environment and they're getting the robot to say things, and it's the robot's speech and not their speech. That's very strange. That's a very strange outcome. And I'm not saying that happens with all generative AI technologies, but certainly a bunch of them, people are behaving as though that's what's going on. And a lot of the new products that are coming out are for the consumer. We're not talking about the smaller, frankly, more interesting things happening in the background. Those also seem like the environment is getting more and more enclosed, And it is more and more people are like, especially like the persona chatbots and so on, they're not thinking of these things as things they themselves are producing. And I think that that's a really weird outcome. Like, people aren't thinking of these things as pens. They're thinking of them as something else, and that something else is producing the content.
I think that depends a lot too on the user interface, on what the
Yes,
product integration
absolutely.
is for the tool, right? Like, I don't, you know, if your use case when you're looking at that tool is some kind of therapeutic, like a therapy bot, right? Then you're going to think you're talking to someone else, not that you're transforming your own speech and having the tool assist you into making your own creative content better or more interesting, or helping you ideate before you even actually start the process of composition, right? Like, there are ways to use these tools where you're not even, as an artist, making direct use of the outputs, right? You could just be using them to help you think about how you're going to do your own composition. And so I just think that the product integrations matter a lot to how users are thinking about what they're doing when they're using these tools.
Yeah.
All right, we've kept the technology and the user barrel for a while now, and I promised we would get to the content industry. So Pam, in your talk this morning, you alluded to a number of wars. I know you used the word war several times, and I know when I was in a law student and I saw Preston Patton and Gigi Sohn fighting every year on the stage, I learned that the content industry and the technology industry were mortal enemies. That was how it was presented to me. Ben, you started in your introduction um, by saying actually the technology and the creative industry are quite aligned, and indeed the creative industry might be one of the biggest customers of generative AI as things progress. Tell us how things have changed on the side of the creative industry. What does that look like now?
Sure. We certainly don't view the technology industry or Silicon Valley as our mortal enemy. Our companies are in business with many of the major technology companies I just described. They have a very productive relationship with YouTube, for example. And our companies are also technology companies. They have been, at the forefront for over a century of sort of, developing both in-house and with outside vendors the use of technology that enhances the production process, going back to the advent of sound and color and all these different technologies over the really over the last century. And most of our companies were founded in the 1920s. So that's nothing new. But again, they've been using AI for decades, mostly kind of in the background and some of these more technical, as some people like to say, boring parts of the industry and the post-production process. Things like color correction, de-blurring and de-aging, rotoscoping, which is the process of sort of aligning computer-generated images and sort of real-life images in a particular frame through machine learning. That can be done, used to have to be done by hand. Then it was done sort of frame by frame with using editing software. Now it can be automated through machine learning and sort of the machine is essentially applying what it learned in the first few frames to thousands of frames. It can be done much quicker and more efficiently than it's been done in the past. So, our studios have embraced AI. They're bullish about AI, but there are responsible ways to use AI and irresponsible ways to use or develop AI. Again, 3 of our members have filed lawsuits over the last several months, or early this year, I guess, against 2 AI companies that, in their view, were not behaving responsibly, obviously, that completely lacked guardrails against production of characters and other material on the output side that were clearly infringing. There's a lot of sort of complicated legal issues embedded on that about, on the input side and the output side, direct liability versus secondary liability that I'm sure will get litigated over the next several years. But yeah, I think the message is overall, we embrace that new technology when it's used in responsible ways, when it's developed in responsible ways. But the fact that there's this amazing technology obviously doesn't obviate copyright law. And a lot of these older doctrines still apply with equal force today. The precise details, of course, will be worked out in those now 59 cases that will take probably several more years to come to a clear conclusion.
Pam, I want to come to you on this. It feels fear of the creative industries on stage extolling the virtues of technology that makes widespread copyrighted works. Conferences where that has not been a feature before. What's your reaction?
Well, I think that there have definitely been times when the tensions were extraordinarily intense. And I would say that in the 1990s with the white papers, extremely broad interpretation of copyright as applying to every temporary as well as permanent copy of works in the world, and the notion that online service providers should always be strictly liable for infringements, even if their users did stuff that they didn't know about and that they were unhappy about. And I would say the rhetoric about copyright back then was pretty intense. I'm going to tell you my favorite insult that has ever been lodged against me. Okay, so so I was at a conference in Los Angeles during the height of this war, and one of the speakers actually said some nice things about me. And then the next speaker got up, and he was vice president at Columbia TriStar. And he said, in the circles I travel in, Pam Samuelson is known as the Joan of Arc of the people who want to steal other people's technologies. And on this issue, I stand with the church. Burn that bitch. It was such a vivid image.
All right, Sarah, tough one to follow, but Verge about the entertainment industry competition and consolidation. What do you make of this sort of alliance between technology companies and the content industry about around generative
Yeah,
AI?
I mean, like, I think that what we've seen is that with consolidation, with like the deals that these companies have made, like we still think of like Fang as tech, and we think of like Disney as content, but that's like simply not the reality when you like look at how the economics play out, right? What is actually the difference between Netflix and Disney? Is like it's they do like they're branded a bit differently, but they're both they both produce content in the form of studios. They both have streaming platforms, competing streaming platforms. I think that what you're seeing is that all of the content industries that have aligned themselves with the tech companies are content industries that have themselves converted into technology industries. The remaining industries that have realigned and shifted on fair use, especially the news industry, New York Times and so on, they are industries that have not quite made the move over into also being a tech industry. They have made significant progress. The companies that are surviving are the ones that have converted themselves into partial video game companies, right? But what else is Wordle? But one massive subsidy for journalism. It is, however, like the industries that remain sort of upset about generative AI are the ones that haven't quite bridged the hurdle. And I think that's one way to make sense of how weird the realignment is. Because it's weird. It is weird. Like nothing about this is the same as the last time.
Before we leave this topic, Anne-Marie, there's probably a day where I might not have sat you and Ben right next to each other on the panel out of an interest in preserving civility yet today. How does it feel to be on the tech industry side of this alignment?
I mean, it feels good. There are still challenges, you know, and I think we are finding our way with partners in terms of build mutually beneficial relationships and products. You know, I think, you know, Google's now having cloud as a major part of its business has, you know, caused a lot of this realignment. Like a lot of these major companies that are content creators are cloud customers, you know, and so it's not just the relationships with YouTube, it's a lot of relationships with Google Cloud as well, where cloud is helping these companies leverage, you know, Google generative AI models and fine tune them, you know, for their business purposes. So, you know, I think it's a good thing. I think probably all do better when we try to cooperate and work together, you know, I think are kind of like a necessary sort of way of sort of working things out initially when everyone is freaked out, you know, but then I think as they make their way through the courts and as this process of domestication happens, they fade into the background, you know, and often by the time they reach the Supreme Court, the industries have already kind of realigned. You know, I mean, I think Netflix started out as a tech company that just did distribution, but realized that it wasn't a working business model if they couldn't also create content. So I think there are also a lot of convergences that happen, you know, and, you know, it was an important moment, I think, when Netflix joined the MPA, because I think that altered the relationship between other tech companies and the MPA, right? Because Netflix was there in the MPA as a kind of, you know, as a company that was situated in both places and understood both points of view.
Ben, one more question for you before we primarily a plug for the afternoon's panel. But one issue that we put on the table is the copyrightability of AI generated works. And this feels like a pretty, the notion that we have a technology whose outputs we're suddenly really questioning whether they are going to get copyright protection. And indeed, early signs suggest the Copyright Office is not so much on board with that. And obviously, the creative industry has been quite on the side of copyrightability. Give us a preview of that issue and how you're approaching that.
Sure. So this is the issue of, you know, if you use an AI tool in some respect to create a new creative work, does that ultimate work still merit copyright protection? And in March of 2023, which is only, about 5 months or so after the release of ChatGPT to the world, which kind of, you know, sparked all this debate, the Copyright Office put out guidance. And they took a pretty hard line. What they said is that if you use a generative AI tool and prompt it with a prompt, then the output is not protected by copyright, end of story, full stop. In a number of subsequent sort of internal cases at the Copyright Office where people tried to register works that they identified as having been created using AI tools, the Copyright Office sort of went even further and said, it's not just that if you use one prompt, it's not copyrightable. In one case, which is actually the subject of litigation right now, the prompter did 624 iterative prompts. You know, make this a little bit bigger, make this a little bit bluer, et cetera, 624 times. And my understanding is that some of the prompts themselves were hundreds of words long. Probably, those prompts were probably copyrightable. But the Copyright Office said, nope, I'm very sorry. That is not your original intellectual conception, going back to the Sereny case from the 1880s, I think, about photography. And end of story, you don't get a copyright certificate at the end of the day. We at the motion picture industry are quite concerned about the standards that the Copyright Office has laid out. And the reason for the concern is, again, because as I've talked about, making a major motion picture in these days usually involves use of AI tools. And some of the content may be either generated or altered using AI tools. And the nightmare scenario for a movie studio is they spend $200 million producing a movie, And then at the end of the day, the Copyright Office says, I'm very sorry, but that's not protected by copyright because you used too much copyright, or as also part of their guidance, the registrant or the applicant did not disclaim the use of the use of AI generated material in their application. To be clear, that hasn't happened yet. And our members have not encountered those kinds of significant difficulties that I think they had feared when that original guidance came out. But it's a real issue of concern. And the Copyright Office may not have the last word on it. As I mentioned, there's this case actually being litigated right here in federal court in Denver, involving the plaintiff, I believe, won the Colorado State Fair art competition, again with his 624 prompt AI image, and it's still in the district court, and who knows how that will come out.
In Colorado, we take quite a pluralistic view of different varieties of art. So I think we'll pick up in the next panel the question of what that has done internally in the creative industry to structure the relationships between creative workers and studios.
Can I
please.
just interject about how new this issue is? There was an AI summer in the 1980s, and it was a hot topic back then. And I wrote an article in 1985 called Allocating Ownership Rights in Computer-Generated Works. So it's new as in, okay, it's not a toy problem anymore, okay? It was a toy problem at the time that I wrote that paper because there weren't any commercially significant outputs that were being generated. And then AI winter happened, right? The last time AI bubble burst was in the 1980s, and then it kind of stayed winter for a really long time. And it's only really recently that sort of the AI summer has gotten out there. And so that's why it's it's new, but it's old.
Says as well, they say, we have been writing about this issue since Barbara Ringer back in the 1970s. And so I want to take our last few minutes before we go to Q&A to bring in the Copyright Office. So when we think about politics, and this is the capital P politics of it all, we have the episode that Pam referred to this morning where the Librarian of Congress, Carla Hayden, is fired by the president. The next day, the Copyright Office releases a sort of unusual pre-publication status report on fair use and generative AI. And then the next day after that, the Register is fired. And I think I've got the timeline right. The next day after that, the president purports to appoint an acting librarian and an acting register. Did I get the timeline right, Pam? Okay. That is not the Copyright Office is not an agency that we frequently see the White House descending upon in such a visceral sort of way. How do we make sense of the broader politics that have led to that incident, which is now sitting before the Supreme Court on the emergency docket? And Sarah, I know you've thought a lot about this, if you want to kick us off.
Yeah, so we broke the story that the people who were appointed, I think the narrative early on was that essentially the Elon Musk, David Sachs contingent had gotten at least Shira Perlmutter, the Register, fired. And that was what our reporting bore out as well. But we broke the part of the story where the people who came in and replaced the Hayden and Perlmutter were part of a different faction inside of the palace. Essentially, the News Corp Bannonite types had intervened, and they had gotten their guys in who were people from the Justice Department whose bona fides were that they were kind of antitrust guys, which meant that they were anti-tech, and therefore they had stuck their thumb in the eye of the Musk-Sachs alliance. That's a very weird outcome. That's I think that might be sort of the epitome of copyright politics in the new era. You've got some very strange bedfellows through that entire thing. And yeah, I don't even know what to say about that. I'm not sure any of these people are even particularly engaged with the law of fair use, to be honest. Someone who had like any, I guess, big picture insight into how copyright works would not have fake fired Shira Perlmutter, because the Copyright Office doesn't determine what copyright law is. Like this pre-publication report doesn't actually do anything. So what's the point? And like, because of that, you get a lot of actually some very fascinating folk theories around what happened here. Like from people outside of law and copyright law, I've heard people say like, oh, didn't they do that so that they could take over all of the works inside the Library of Congress and train on them? And I'm just like, oh my God. Like, it's like, because it's just, if you know anything about the technology stack inside there, you go, wow, if only. If only that was possible, because then it would mean that things had gone much better inside of that tech stack than they currently are. But it is like, I don't think that the people who targeted Hayden and Perlmutter understood what they were doing and what was at stake. And then I don't think that the people who came in and got their replacements in understood either what was at stake or how any of this works. And yeah, it's a very strange degradation of the political situation.
So maybe before we go to Q&A, Pam, any thoughts on the significance of this intervention at the Copyright Office and what that means for the future of copyright politics?
So I think the people in the Copyright Office were trying to keep their heads down, in a number of other places that are kind of like a little more on the obscure side, not as kind of wokey worrisome for the Trump people. But a dynamic here that I think was significant is that the Library of Congress and the Copyright Office are, at least officially, part of the congressional branch of government. And the Senate doesn't seem to be doing anything, except that they don't like the idea that the president can basically come in and mess with their people. Now, when it comes to the firing of the Librarian of Congress, that's actually something that the president has the authority to do. He doesn't have the authority to fire Shira. And so that's the issue that's before. But I think that the Congress may not be willing to stand up and fight for SNAP benefits, but they don't like the idea of their own authority being undermined by the president as directly as these firings seem to suggest. So there was just a teeny bit of backbone shown by the Senate Majority Leader when these things were announced. And, and I think the people in the Copyright Office has just tried to sort of keep doing what you're doing and keep going and, I mean, until the shutdown, obviously. But I think that the expectation is that if and when a new librarian is appointed, that new librarian can fire Shira and put somebody else in. But so far that hasn't happened. And but I think there is the other dynamic, in addition to the thing of the certain MAGA people wanting to get rid of anything that's cultural, and the tech people saying, excuse me, you owe us, and therefore you got to come out in support of fair use. And so that's actually a tension within the Republican Party right now.
I think there was one other aspect of the congressional, like, I wouldn't call it a backlash, but a little bit of the pushback that came from that, which is that they were concerned about the Congressional Research Service.
Yes.
And that, I think, is something that they really, really want to protect, right? The Congressional Research Service is an arm of Congress that provides expert guidance and writes reports for Congress people to help them sort of understand how to come out on certain policy issues. And I think they were very worried that something was going to happen to the CRS.
Well, and the Copyright Office for Congress also.
Right.
And so that's a place where they have some common interest.
Yeah.
I cannot help but plug my see separation of copyright powers coming out in the Seattle University Law Review. With that, I'll open it up to questions. And I see a student hand right off the bat. Let's go to Max.
Sure. Thank you all for that wonderful panel. I'm thinking of what Pam was saying about the days of Napster and how users drove the music industry and many industries in some ways to change with different models and convenience. Even though it was blatant copyright infringement, convenience won out, right? And users wanted that. And I'm thinking about the fair use factors, and as Professor Reid calls it, the hidden fifth factor of maybe vibes, and how with Google Books, Perfect 10, there's this, clerks, researchers, people really love these products. People love iTunes. People love what Spotify became. People loved Google Books, right? And with AI, I know there's a lot of LinkedIn thought leaders who tell me I should be using it in many ways, but the public reception seems more mixed. I mean, obviously, it's not just the creative community. It seems users are kind of skeptical about like Google AI summaries. Maybe they're better now, but when they launched, that was a big controversy. Lots of these features, the existence of the term slop is really the public pushing back on industry. So keeping that in mind, how do you think that factors into how judges in the law might think of public interest with fair use?
Factor 5, a jump ball.
I think that you would have to see some significant evolution in the law. I think that's actually what the Kadri case is, where, it was a weird swing, but I think that they're looking at the facts and going, well, this is really strange. This is, how can we make things look in a way that's not totally discordant with how the public perceives this stuff? I think you're right. I think the users are showing in their revealed preferences, and it's very hard to see the revealed preferences because of the way these platforms are set up. They're owned by companies that are pushing their own Gen AI products. But I don't know, you see one slop video, all the comments are people yelling about how it's slop, right? You see, and I find this really fascinating. It's half people saying, oh, this is slop, that sucks. And then tons of people going how could you waste 5 million gallons of water by generating this? So they'll talk about the environmental implications, the carbon implications, the threats to the artists. I'm just I don't think you actually care about any of these policy concerns. You're just trying to find a reason why you hate this. And you've seized upon what people have reported as this is why AI sucks. And so you're seizing on this reason, but ultimately you just don't want to look at this content. But there's no toggle on TikTok to be oh yeah, I never want to see slop ever again. Or more frankly, the problem would be Instagram or or YouTube or so on. Yeah, it's really weird. It's a really weird outcome. And every layperson can see for themselves the difference between Google Books and ChatGPT. And yet the law doesn't differentiate as cleanly. And that's weird. That is a very, very weird outcome. And I think that is driving a lot of the splintering also. We're trying to make sense of what it is that all of the lay people understand and trying to put that into words, and it's not coming so easily.
Okay, next question. I got one from Zian back.
Hi. Okay. So, Sarah, you started your talk by talking about the progress clause. And I think maybe part of the reason we feel like copyright doesn't have the right language for us is because we've never really had a definition of what it means to have progress in the sciences. So I think AI boosters typically will point to AI generated content and say, look at how great this is. Consumers have voted with their preference. Everyone's using it. We have millions and millions of users. They use it every day. People like the content. But I also think we've seen the failure of that type of consumer welfare language in other areas like antitrust, which I know you're interested in, and how the past decade has really seen a failure of the 1980s Borkian style consumer welfare, where what we're really talking about is more output is good output. And if consumers vote with their wallets, that's also positive. But of course, I think the counter critique to that is that outside of measurable outputs, quantity, how do we figure out if something is good in the abstract or bad in the abstract? Although in other areas, I would say outside of antitrust and IP, we don't really point to consumer preferences, right, to decide whether we like something. It's not like in the tobacco industry, we said, look, everybody's buying packs, it's amazing. So what would you advocate is a definition of progress that would be satisfactory, to replace maybe consumer preference?
So this is the part where I get to pretend I'm not a lawyer and not have any policy recommendations. I think this one's a really dark one. Like, I think that we have never seen a paradigm shift like this before, and therefore we don't really have adequate tools to address it or like conceive of how to address it. I would love to hear your own thoughts on this one. I do think that the revealed preferences thing, though, is complicated because they say like 180 million active users. But if you look at sort of how people are using ChatGPT, aside from like the problematic uses, which that's not going to be like the majority of uses, majority of users are using ChatGPT as a search engine. And they're using it as a search engine because the premier search engine, apologies, of the past like 10, 20 years, it no longer works particularly well. And it no longer works particularly well because its results are flooded with AI slop. So it is ultimately a very circular problem here. And I don't know if we are actually seeing revealed preferences by those daily active user numbers because it is like, that is so weird to measure. I do think, though, that things are maybe moving so quickly that we might have a problem in being able to measure progress because the tools are disappearing to be able to measure anything really. And that's pretty scary. That's a scary place to be. Maybe we'll be fine in the end because the bubble will pop tomorrow, and then we're just going to be left picking up the pieces. But yeah, I'm not really sure what the right definition would be.
Yeah, I think we might be over-indexing on chatbots when we think about the value of AI and how AI can promote the progress of science, right? Because there are tremendous strides being made now. The LLMs that are underneath chatbots are also underneath, discoveries related to protein folding, right? To drug discovery and development, to weather prediction, especially in the era of climate change and how important it is going to be able to predict the weather. So there are just a huge number of sort of scientific uses of this technology that are not related to whether or not I'm making an image of Mickey Mouse. And I just think we have to be careful not to forget or downplay all of the amazing things that are happening in the sciences and engineering with these models that are not sort of the GAI models that are making it into the pages of the New York Times sort of every day.
Isn't it the case that all the copyright fights that we're having are about the chatbots? In other words, we're not seeing litigation over the use of AI in the pharmaceutical industry, that sort of thing?
But the base models are needed to train with copyrighted materials, right? So it's the use of the copyrighted materials to train these models. These are like the same models, right? They're being fine-tuned for different purposes. They're being developed for different purposes, but all of the models, for weather prediction and everything have ingested huge amounts of copyrighted content too. And sometimes they are the same models that are underlying the chatbots and the consumer-facing products that are generative tools.
I'll let Zian bring this up later, but at her talk yesterday, I think her observation was in a lot of these more sectoral models that the copyrighted works are actually licensed because the collective licensing issues look really different. But I think we have got time. I'm looking down the panel for any other reactions. Seeing none, I think we've got time for one more question before we go to lunch. Why don't we go right here?
So my question was, you had spoken, and this is for Anne-Marie principally, but well, welcome to any respondents. Anne-Marie had spoken principally or partly about this concept of AI being very valuable because it can produce like parody, it can produce transformative works. But to Ms. Jeong's point, I know oftentimes these users who are producing these works aren't seeing these as works that they are producing themselves. It's not their individual speech, but instead something that they are somehow prompting to receive from the system. I'm wondering if you see sufficient listener value in receiving that parody in order to protect it under fair use. Or if you see a more, because this was under the topic of guardrails, if you see a more efficient place where we can put these guardrails, where we can protect that fair use, but still prevent it then from being taken and used for copyright infringing purposes.
So I think the framing of your question really kind of conflates the First Amendment speech questions with the copyright questions. And although they're related, they're a little bit distinct, I think, right? And any sort of copyright lawyer who reads the copyright precedents will tell you that we don't make aesthetic judgments when we assess when something is copyrightable or copyright infringing, right? Like what is protected as a parody, whether you think it's a good parody or not actually doesn't matter for purposes of a fair use analysis. And so I do think we need to use a lot of care about where we put the guardrails because I think that, I think that the speech issues are a little bit orthogonal to the question.
With that, it is time for us to break for lunch, but before we go, lunch will be upstairs. So if you walk out these doors, for those here in the room with us, up the stairs behind them, and then take an immediate U-turn, you're literally right above us. We are going to reconvene at 12:45 Mountain Time for our second panel. And before we go, please join me in thanking the panel for a wonderful conversation.